One of the things we'll be talking about today is life insurance. So we have someone here from New York Life, it looks like. So you'll be happy to know that I'll be talking a lot about life insurance. And that is a big portion of what we're doing with our young parents. So feel free to comment. We do use different metrics when we're talking about how much life insurance a parent should have. And if you have a certain metric that that's great. If you have a certain metric that you're used to when you counsel clients, I just put this in front of my face. How's that?
Perfect.
Stick it up there, Tim.
Is it only Lizzie?
No, there's two others. So we'll be talking about some of the metrics we use to determine the appropriate amount of life insurance. But I know there's different ideas out there. So it's either some are according to your income, some are according to the number of children, some are just general multipliers. So things like that. So when we get to that point, which will be more towards the end, please feel free to jump in and give me your thoughts on it. I do think that life insurance is absolutely critical when you have children under 18. And if anyone has paid for college in the past few years, then you'll know what I'm talking about when I say you need life insurance to, at the very least, cover college costs, but more importantly, even to cover lost wages for the lost parent, lost spouse. The issue now, of course, is that most of our young parents are both working. Gone is the day where one is working and one is home. Although it does happen, it's certainly not the rule anymore. It's the exception. So lost income becomes really, really important in addition to covering college costs, which for those of you who have ever been in it, you know how astronomical that is. Having assisted in putting 3 kids through college already, I can tell you it's painful. Okay. All right. I want to wait just a few more minutes till 5:15, so that I make sure that if anybody else wants to come on. Unfortunately, I should say fortunately, this COVID, if there's a bright or silver lining in all this, we've gotten a lot better with our technology. I assume everyone out there has, working from home, doing meetings via Zoom or any of the other technology that's available. And what it's done is really created a new format for us and for us to feel a lot more comfortable using this kind of stuff where even 3 months ago, I wouldn't even considered it. But it's put it right in our laps. And so we figured we would use it and start off by talking to our young parents because they're more inclined to use the technology than, say, our older clients over 65. So we thought it would be a good way to get to you and talk about some of these issues. I have also realized that during this period of time where people are stuck at home and working at home, that they found that they've had both a little more time to deal with estate planning as well as are more inclined to deal with it, having been faced with some of this the reality of dying, right, because of the virus. So I've had a lot more young people call me during this period, even more so than our older clients, primarily probably because the older clients are a little more afraid to even venture outside at this point. So it has been life-changing on many levels for us. And again, trying to find the best and brightest points of this is one of them, the use of technology. You guys on the other hand, get to stay anonymous to us for the most part. And so, you can say all kinds of funny things during these and we don't know who you are. So that's not an invitation to be a wiseacre though, but I do appreciate that you're frank with your questions because that way you don't feel like you're asking something stupid. Ask it, find out about it. If you've got issues related to your own parents that you might want to deal with, I mean, even at the end, if you want to ask some of those questions, that's fine. We'll have time.
I do
Uh,
also have it set up, Rob, for the Q&A that when people ask questions, the other attendees cannot see them until I basically approve it. So
Okay.
anything they ask won't just pop up to everybody.
There you go. So once again, if you're at all hesitant about asking a question, please feel free. And Lizzie's the arbiter of what's appropriate and what isn't, and she may even be able to rephrase it so that it works with in our nomenclature, so we can answer it better for you. So again, don't be afraid to do that. She will vet them and get them up on the screen or verbally ask me the question as we go through. Okay? All right. Lizzie, what's our time here? We're just about 5:15. So what I'm going to do is I'm going to start with some introductory stuff, some of the basics. If people do jump on, that's great. If they don't, that's okay too. So obviously, what we're going to be talking today about is estate planning, and estate planning relative to primarily at this point focused on young parents or parents of young people, because I'm finding that parents of young people aren't always young themselves. Me being a parent of what I consider a young child of 14, I don't consider myself that young either, although I try to act like it, or my wife would tell you that. So what we're trying to do is focus our conversation today on the basic needs for those people and what you should be thinking about, and some really vital mistakes you might be making, particularly as it relates to life insurance and IRAs, okay? I'll also talk briefly about changes in the law with respect to IRAs that started this year, and how that would affect you and your children. Just taking a note so I don't forget to talk about that. And so let's start with the basics. There are 3 basic elements to an estate plan. Every estate plan should have these. And I want to focus in on why I'm getting fuzzy again. So we call it an estate plan because ultimately it's a plan. It is not something that happens by accident. It's not something that the state predetermines for you. It's a plan. If you don't create a plan, if you don't do your own will or do a trust or something that tells the world how your assets should be passed, the state has a plan for you. I promise you, you will not like it. And when I get through with this and tell you what the state's plan is, you're going to understand why I don't like it, okay? It centers primarily around how the assets are distributed when you die, but also how your children are treated. It's really, really important you understand how they're treated if you die without a will. So let's start with the first basic piece, and that is the healthcare proxy. Okay? The healthcare proxy is the first element in a good estate plan. And what the healthcare proxy is, as I'm sure you're aware, it's where you appoint someone to make healthcare decisions for you when you cannot. So if you become incapacitated, if you have a stroke, if you're in a car accident, and you're unable to make decisions, you need someone to do that. Now, about 6 or 7 years ago, New York State decided that because not enough people were getting these things done, that they would create their own plan or their own hierarchy as to who can make these decisions. So thankfully, there is a backup plan in case you don't create one. However, you should create one because in yours, we want to have some things. First of all, we want to have some rules on how you want to be treated at any period of your life. But more importantly, how you're treated at end of life. So for instance, what happens if you're being kept alive only by machines? Do you have a feeling one way or the other as to how that should be handled by your agent, by your healthcare agent? Should they make a determination to end your life by withdrawing life-saving measures? How do they know that that's what you want? These are things you should have in writing so that the family understands it. I also suggest that you have a conversation with your spouse about it, or a conversation with your agent, whoever it might be, your oldest child, your brother, your sister, your mother, and explain to them how you want to be treated. The family, everyone around you should understand how at end of life you wish to have that handled. You also may consider putting in there some plans about how you wish to be treated after you die. Do you want to be buried? Do you want to be cremated? Where? What are your plans? Young parents, young people tend not to make these plans with a funeral home. And because of that, what you're left with is someone having to guess a little bit about what you wanted. So you should at the very least have a conversation, but also we put after death rules in there. You want to be buried. You want to be cremated. So we ought to be able to understand how you want to be treated. So the healthcare proxy is really critical in appointing someone to make those decisions, someone you trust, giving them some understanding of how you want to be treated now and after death. And you should have an alternate as well that you trust. So you have a primary, generally speaking, your spouse, if you're married. Again, could be a parent, but if you have young children, like I know you guys do, then what you'll be looking to is probably a sibling or a parent to be the alternate as opposed to a spouse, okay? So the healthcare proxy, really, really important, probably the most basic and easiest piece to put together. I do suggest that, Tev, I do suggest that you also make sure that your family has a copy and you keep it somewhere where everybody knows where it is. I'll show you what we do. Tip, give me a tube. So what we do when we do these for you is we have you give them to your primary agent, but we also have you put them in your freezer so that if something should happen, everybody can find them and we know where they are. So it looks something like this. It says healthcare proxy on it. We have a little sticker that goes on your fridge and tells the EMTs where to look. And if you have to go to the hospital, you'll always know where it is. You grab it right out of your freezer and you take it to the emergency room with you. You should also have a copy with your primary care physician, just so they've got it on file. Okay? So that's the healthcare proxy. Let's talk about the next element. Okay? That is power of attorney. POA. This is extremely critical. And in some circumstances, I would argue that it is more important than your will. Because as I said earlier, the state of New York has a plan for your assets if you die without a will. However, if you have no power of attorney, New York State has no plan for you. In order to make decisions, in order for someone to make decisions on your behalf, if you don't have a power of attorney, they have to become a guardian. A guardian. A guardianship means going to court. A guardianship means spending lots of money. A guardianship means involving 3 or 4 attorneys. A guardianship is bad. Time and money. Plus, also means that you haven't chosen the person you want to make decisions for you. It means a judge has chosen that person, and sometimes it could mean there's a fight. So let's talk about the right way to do it. Power of attorney. What you do is you appoint someone to make legal and financial decisions. This is absolutely, unequivocally critical. And while it's extremely important for folks your age and my age, it's extraordinarily important for people your parents' age or your grandparents' age. I've had more than 5 calls during the COVID crisis period where someone went into a nursing home, incapacitated, disabled, incommunicative in some instances. They don't have a power of attorney, and the loved one at home, most of the time a spouse, is trying to make decisions for them, transfer assets, move things around, protect assets, file for Medicaid, and they can't do it because there's no power of attorney. You literally can't make decisions for your spouse if you don't have this. There is no other legal remedy. Just because you're the spouse doesn't mean you have the right to make those decisions. So you need to be appointed in this. Really important. And while the power of attorney doesn't give necessarily a series of rules or ideas or even directions, it does give powers. And the hope is that the person you've chosen, again, probably your spouse, they understand how to use those powers for your benefit. Moving assets around, applying for Medicaid, paying your bills, making sure you don't go into foreclosure, any number of things. Because sometimes these issues are only temporary. You have a stroke, you have a recovery period, you're back on your feet, but during that period of time while you're recovering, you need someone to make sure your bills are paid. Dealing with insurances, whether it be health insurance or disability insurance or Social Security disability, all these things, you need someone to do that, okay? So really, really important. Now, there's another piece of the power of attorney that is also extremely important. That's called the SGR. The SGR stands for the Statutory Gifts Rider. In 2009, New York State added this element to the power of attorney because out of so many complaints from children stealing or anyone stealing from people as a power of attorney. So what they said was, in order to move assets out of a person's name, you have to have the statutory gifts rider. Now, in our world, in order to do planning, financial or Medicaid planning, we have to have the statutory gifts rider so that we can move assets from the disabled person's name to somewhere else, whether it be to a trust or to the children or someone in order to protect it. Must have the statutory gifts rider. This is not even an issue. This is not a question. It must have it. So if you currently have one, or if you know of your parents having one, and it doesn't have the gift rider, it needs to be done. Really, really important. Because without it, we literally have no flexibility. We can't move assets out of your name. We can't move your car out of your name legally, technically, the house out of your name, assets out of your name to protect them, all these things that we might need to do should something occur where you're in a nursing home or some other serious situation. So consider that very important. So I can't stress to you enough how important this is, okay? If you take nothing from my talk today, you should really make sure you get a power of attorney done. All right, so healthcare proxy, power of attorney, the first two important elements in a good estate plan, a good basic estate plan. Now, for my young parents, I'm going to talk about the next step. Let's see, maybe we'll go this way, okay? We're going to talk about the will. Now, there are a couple ways to tackle the will when you're young and when you have young children. I'm going to say a couple things that are going to sound funny, so just understand the spirit in which I say it. First thing is, when you do a will, and when we create a will-based plan, my hope is that you never die with this plan, right? What I mean by that is this will is created as a backup plan that you die unexpectedly in an accident, have a heart attack, die in your sleep, one of those things that we didn't see coming. What it isn't built for in the perfect world is if I am informed ahead of time that you are likely to be the one to die first. And the reason is that I would take a more aggressive approach to how we did the estate plan if I knew who was going to die first. But most of my young folks aren't going to die anytime soon, right? So the plan is for that accident, just the possibility that you die. Very, very important because those things do happen. But nonetheless, it's built for something unforeseen. So I'm going to talk to you about the basic way to do it, or the more traditional way. And then I'm going to take a couple more steps and talk about a little more advanced will planning and blended family planning and remarriage protection. Okay? We'll talk about how that works. So, basic plan, traditional plan. We have husband, we have wife, right? By the way, I always kill the husband first. That's just the way it is. We've always done it this way, so just bear with me. So, husband here has IRA money. He has life insurance money. He's got some investments, but most of his stuff, like a traditional husband-wife, the house is owned jointly. I'll call this the joint assets. The bank accounts are jointly owned, and probably we'll call the cars, and even the investments are jointly held, which means that this will travel and become owned by the person who survives. So let's say the husband dies, all the joint assets now belong to the spouse. Easy. This stuff, generally speaking, will be distributed to the wife by beneficiary designation. correct? Easy, right? We always name our spouses, sorry about that, primary beneficiary on life insurance and IRAs. And in the most cases, in the basic planning, I agree we want to do that. Not all the time. I'll talk about when we don't want to do it. But what is the biggest issue we face? And I want you to ask yourselves when I ask you this question, what is the answer? Who is your contingent beneficiary on your life insurance and your IRAs? Think about that for a moment. Is it the underage children? Is it your brother or sister or parents because you trust them to take care of your children? Is it nobody? This becomes the biggest mistake most people make. So I'm gonna come back to that in a minute when I talk about how it should be set up. Okay, let's spend a minute talking about life insurance and a little bit about how much life insurance you should have and how life insurance works. So life insurance is easy, right? It's no income tax, so it's tax-free cash when you die. I can't say there's no estate tax on it, but since the exemption is now $5.85 million per person, we're only going to worry about income tax. There is income tax on IRAs, as you know, they have yet to be taxed. But if you leave everything to your spouse can do a rollover, zero tax. Easy. Now, let's say husband here has $100,000 a year of income. Depending on who you talk to, they're going to tell you that he needs between 10 and 12 times his salary to accommodate his loss of income and the college tuition that we're going to lose, right? That they're going to need to pay for these children. Let's assume there's 2 children here. For those of you who don't know, college tuition, private school, is about $300,000 per child. Now that may change. I think this COVID environment has changed colleges and their perspectives. I just heard yesterday a local college is going out of business. Hard to believe, but it's true. So what this means is this person, let's say this guy's got $1.1 million in life insurance. That's a lot of money, right? And he leaves that life insurance to his wife. His wife now has $1.1 million. Now, these guys are 35 years old. So what happens is she's now got $1.1 million. Awesome. About 6 months, let's make it a year. After he dies, she gets remarried. She remarries Stan. We always call him Stan the Stud. Okay? She remarries Stan. She changes her will. Her will now leaves everything to Stan. Stan, by the way, has 2 children of his own that are not related to these children over here. Is this a good plan? Was this a good move? Is this in the best interest of husband's children? Okay? I don't know, but let's talk about alternatives to that. So, again, $1 million, $1.1 million in life insurance. Let's consider an alternative. So, here we have life insurance, we have IRAs. Husband again, instead in this case, what the husband's going to do is he's going to leave his life insurance to a trust, right? $1.1 million in a trust here. Now the trust is managed by the spouse and husband's brother. Together, they're managing the money. How's that? The IRA goes to the spouse. I still like that idea. That's okay. But now the $1 million in life insurance is in this trust. The beneficiary is the spouse. That's okay. But if the spouse dies, gets remarried, and then dies, this money goes to husband's children and not to Stan's children, right? The idea is we want to be sure that the funds end up in the right spot at the death of both of the parents. Really, really important. Let's talk about how we create this plan if both parents die at the same time. There are 2 ways to do it. One's good, one's better. So let me just erase. Actually, I'm going to skip over and erase this next one. So this is where we talk about how you set up and designate your beneficiaries. So I know we've got an insurance guy watching. I hope he's still there. So this is how we do it. Life insurance, again, I'll go back to the basic. Spouse primary, right? They die in a common accident. Now we're triggering the contingent beneficiaries. What do we do here? Well, an easy, low resistance way is to make your estate the beneficiary, contingent beneficiary. Again, not your mom, not your brother, not the children, because remember, they're 10 and 6. And what happens if 10-year-old and a 6-year-old inherit the life insurance? Anybody know? Here's how it happens. Money goes into a guardianship account for them. Hopefully you've chosen a guardian, but if you hadn't, then the family gets to fight over who's going to be the guardian. Another great result. More time, more money, more effort. Guardian's appointed, goes into a guardianship account. The guardianship account is set up until they are 18 years old. In order to take money out of the guardianship account, you must get a court order to do that. You can't just simply write checks or ask for money. You need to go back to the judge and say, hey, judge, we really need $50 for these new sneakers. That's a joke, by the way. There are no such thing as $50 sneakers anymore. Okay? Judge, we need $120 for new sneakers. You can't go back to the judge every time you want a new pair of sneakers. It just doesn't happen. So what happens is, once in a while, you might make a big expense, but primarily the money sits there till the children are 18. Oh, and then, by the way, at 18, they can go and take all the money. Anybody here, by show of hands, want their 18-year-olds to get, I don't know, $1 million, $500,000? Of course not. Nobody wants that. That's not a smart idea. So instead, what we do is, if we make the contingent beneficiary of the estate, it'll come through and to go into trust for the children. Now, here's the benefit of the trust. First, it's in trust till they're 25, 28, or 30, or something like that, not 18. Second, the trustee has the authority up until whatever age you set to distribute the funds to the children as they need it without asking the judge for permission every time they want it. You want new sneakers? Here's your $100. You want gas for your car? Here's $50. You need tuition money? Here's money. Everything they need is available from the trustee. Much easier, much less friction, much more control until an age at which you determine they're appropriate to have and control this money. I can promise you, though, 18 is not that age. And in fact, in my 15 years of doing this, I've never once gone to 18. The lowest I will generally go is 25. If there's a very little money, we might go to 21. But you have to remember, kids are in college, 21, 22, still being affected by peer pressure, still being in an environment that if they had lots of money, they'd be very susceptible to trouble at that age. And so what we're trying to do is get them past that, get them to at least 25, where they're hopefully out on their own and may be ready to manage some of this money, okay? So making sure the money goes into the estate, into the trust is the easy method. The problem with this method is that makes the cash available to creditors. And creditors, if this, let's say there was a car accident and the estate got sued for killing 5 people in a van. Now the life insurance is available to that lawsuit. We don't want that. So the better way to do it is to take the life insurance and have it payable to the 2 trusts. So we can actually set up the designation so the money goes to the trust. And you can also do that with the IRA money, 401k, IRA, TSP, TSA, 403b. Any of that pre-tax money can be payable down to these trusts. Okay, money goes into the trust, and now the children have guidance and are overseen by a trustee that you've chosen, handpicked, to manage the funds for them until they turn the right age. So again, this is a plan.
We have a good question.
Okay, go ahead.
I don't know BP Pfaff's real name, but BP Pfaff asked, can the age be changed if necessary by the trustee?
I didn't hear that, Lizzie, sorry.
Can the age be changed if necessary by the trustee?
I would say that generally we don't write it that way. So the question was, you guys heard that, can the age here be changed by the trustee? What we do is there's a couple of options. We don't generally change that, but you can write it into the will. What we do always put in there is that the trustee has the option when it's time to turn the money over to the young person. And if they determine that this is not well suited for this young person, they can buy an annuity with the funds so that the child gets a monthly payment the rest of their lives instead of $500,000 that they can mess up their life with. So there is that backdoor option, but I would say that if you were concerned at all, we can build it in where they can change the age. Or if you're not sure about your child, we just raise the age and allow the trustee to go earlier. Okay, Brittany, right? Thanks. So what it allows them to do, if let's say we started at 35 and then told the trustee, you know, if you really think they're okay, you can give it to them earlier. But if they're not okay, we're going to stretch it out to 35. So that's kind of the opposite of what you asked. But the truth is you can really do anything you want. And depending on how you feel about it, we can build in all kinds of things. But you need to build it. And you're building your own trust right here. It's called a testamentary trust, but you're building that for them, okay? All right, so we've covered a couple different ways to leave the life insurances and the IRAs to your beneficiaries. Key is to remember is not directly to them and not to anyone else directly. It needs to end up in the trust. It needs to, at the very least, be down here where the court can keep an eye on it if it really had to. Okay? Really, really important that you consider that and how you set things up. So again, do you have the right amount of life insurance? You need to think about how much you earn, how many children you have, what your spouse earns. Okay, can your spouse live without your income? You need to think about that. You know, invariably, because life insurance, term insurance is so cheap, if you're a 35-year-old, particularly 35-year-old female, I mean, Brittany, jump in here, but $500,000 in life insurance is like $13 a month or something, right? If you're healthy. So, I mean, really, it's dirt cheap to protect your family. And I don't sell life insurance. I just know how important it is. I've had more than one client pass, one recently, totally underinsured, put the family in a desperate situation. I also tell my older clients, my seniors, to pay for their children's policies if their children are struggling buying the policies. I just say, listen, what a better present can you provide than making sure you pay the premiums for your children's life insurance? And they love the idea. So any number of ways to make this happen, but it's really, really important, okay? So let me just make sure I've covered life insurance, the different ways to use it, how the IRAs can be left, creating that trust, going back to that other plan, right? The higher level plan, which was when the first spouse dies, we create a trust with the life insurance, even the IRA if we want to, putting it in this trust. Now, trust is for the benefit of the spouse, then it goes to the children. Now let's talk about blended family planning, because blended families are so prevalent right now that we're constantly having to review how we leave assets to families to make sure that your children get something as well as her children. So we'll use, let's use any family. Husband and wife each have 2 children. Their own children, they have none together. The two of them have differing interests. It's very clear. Yeah, I didn't see the whole thing, but I see 20, less than $20, right? $20 a month. Pretty cheap for life insurance, she says. And it's really, really important. So, but let's talk about the blended family, because this is where the rubber hits the road for a lot of people. When you've got children on each side, how do you make sure you accommodate leaving something to both children? So here's what we might do. We could use the trust for the spouse, and that's a great method, but it's not perfect either. So here's my thought. Nowadays, people are the boomers, right? Even more importantly, the next generation, my generation, whatever we are, Gen X or whatever, and then the millennials are working on building these great large IRAs, 401ks. So one of the things they can do is instead of leaving your IRA, I call it generically an IRA, okay? Instead of leaving the IRA completely to the spouse at your death, instead of going spouse, you might say, wait a second, I want to leave some to my kids. So I'm going to leave 25% to each of my kids, okay? And leave 50% to my spouse, because my spouse works too. And he or she's got a large 401k already. Plus, I'm smart and I have life insurance that I'm leaving to my spouse because I'm smart and I'm making sure all this stuff works. Or you can do the converse. Leave all the IRA to the spouse and life insurance to the children's trust. Okay? So for you, Brittany, when you're talking to your clients about buying life insurance, there's many reasons to use it. One is simply creating a legacy. It doesn't have to be for anything more than, wait a second, I want to be sure because I'm in a blended family and we have different children, that my children get something when I die, and I'll leave the rest to my spouse. And if she turns around and gives something back to my children, that's great. But guess what? I live in the world of reality. Okay? Reality says and dictates that the surviving spouse is not going to leave anything to non-children. If you presume that to be the case, then you'll be much better off if you do a plan that includes the children at the first death. And this goes on both sides, right? Because if they both have children. So if you presume that, then you can create a plan that covers it. If you don't presume it and hope for the best, that's not a plan. That's what we in the business call a gee, I hope it works. And a gee, I hope it works is not a plan. We want a plan that gets us where we want to be when we die. Again, not one of these is going to be perfect. It's a question of meeting your goals. If you have a series of goals, maybe not all the goals match each other, but meeting as many of your goals as possible in any way we can. You know, it could be that you don't qualify for life insurance. That changes the perspective. It could be that you don't have an IRA or a 401k. That changes things, doesn't it? So all of these elements become part of the conversation when we go ahead and create this plan. But that's why it's very important to know all the pieces of your financial situation, all the pieces of your family situation, your personal goals, your interests. Even if you're young, might you inherit something later, right? That's a piece of your potential future. So these are the things we ask to find out about you so that we can make a plan that fits you. There is no, particularly for young folks, there is nothing that's cookie cutter. Trust me. And when I showed you the original plan, we call it the sweetheart will, everything to you, that plan, quite honestly, is very rarely used in our office just because it just doesn't fit. Even though it's real simple and real easy and straightforward, it just doesn't fit most of the situations because of people's goals and needs and wants and all those things. Okay? So I want to spend a minute on how the law changed in January. Very important change. What it did was, when people, prior to January of this year, if you died leaving an IRA or a 401k to a child, that child was able to stretch out the IRA and take distributions over their lifetime. And what that allowed it to do is, as you stretch it out and took distributions, the value of the IRA, despite the fact that you would take distributions, would continue to go up because your distributions were small percentage-wise. And so by the time you got to 65 and wanted this money to retire on or older, there was a bunch of it there. Hadn't paid the tax on it yet. And you didn't have to pay the tax or much of the tax while you were still working, which is the worst time to pay the tax, right? You don't want to pay tax on top of your already earned income. So what Congress did, and I think in large part because they need the revenue, and certainly they're going to need it even more now, is that what they now said, you've got 10 years. You need to take the money out in 10 years. We don't care when you take it out. It's just got to be out in 10 years. Well, here, much of the time, you could be in the working period, right? You could be employed, earning income, and then have to take a hit with this extra income. It's hard to plan around how and when to take it out. So there's no perfect formula here. If you're 60 years old and you know you're going to retire in 5 years, yeah, you can push it off and take it after you retire. But if you're in your 40s, it becomes a real difficult prospect of how to plan around when to take this money out and pay the tax, because you're stuck having to pay the tax. And if it's large enough, it's very possible that it's going to knock you up a tax bracket. So you need to be aware of that. And if you're leaving IRAs, large 401ks to beneficiaries, there's certain tactics you should be considering. The first one, so by the way, this is called the Secure Act, which is not to be confused with any more recent, what are the new ones called? The Secures Act or something, whatever. So they're all very confusing. But there are techniques we use to create plans to minimize the tax and reinforce it for our children. Number one is life insurance. Again, consider getting life insurance, consider getting permanent insurance. I suggest to most of my clients, when they're getting towards that 50-year-old mark, they consider buying permanent insurance because they might need it, or they might want it years from now. Always get it when you're healthy, always get it when you're young, right? Number two, Roth conversions, right? You can do that. You convert, you pay the tax, so when you give it to your children, they don't have to. So you have a lot more control over how the money's passed along tax-free to your children. So we've got tax-free life insurance, Roth conversions, you pay the tax, give it to your children tax-free. Number three, stagger the distributions, which means you give at the death of the first spouse, you leave some of the IRA money to your children instead of giving it all to the spouse. Kind of like this plan here, except this doesn't have to be blended family. This is we're leaving our money intentionally to our children at each death, so we can take that 10 years and maybe max it out to 15, 20 years, okay? So a better use of time and money. So stagger your distributions. So these are three good ways to do it. There are more. One of them is leaving to grandchildren. This is a great technique. Now, instead of leaving our IRAs to our children, we're going to leave it to our grandchildren. And they can take it out. They have 10 years, but they have 10 years from their 18th birthday, so they can actually go till they're 28. So if they're only 15, they've got 13 years, and so on. Plus, they're less likely to have to pay taxes or large taxes. So much better place to move it, to put your IRA distribution, see at least a portion of it. So different techniques to transfer assets and keep the taxes down, okay? So that's the Secure Act, some ways around it, some things to consider. All of these things take planning. All of them take time. You need to consider them. You should talk to an attorney. Obviously, we'd love for you to talk to us. I do believe firmly that if you're going to do an estate plan, you should talk to an estate planning attorney. Unfortunately, I will tell you that if you went to a general practitioner, they're not even going to know half of this or half these techniques. They may not even know about the Secure Act and how it works. What we're not getting into tonight, we're going to leave this three or four more weeks from now. We're going to do another one that gets more involved with Medicaid, trust planning, how to use living trusts, why to use them, when to use them, a much longer seminar or webinar and much more involved, but really good points. So if you're interested in coming back and seeing that, we'd appreciate it. Also, send your friends, send your parents, send your clients to come and watch. We think now with this technology, it's a good use of our time. You can sit in your home, you can watch me, you can watch all of it, you can watch part of it, you can have a coffee, you can have a beer for that matter, you can even eat your own donuts. We don't have to provide the donuts, which is nice. But please feel free to give us a call. We'd love to sit down with each of you, any one of you, and talk about your personal situation. As I said, there's no cookie cutter here. So we're going to find that as a result of our discussion, we're going to come up with a plan that works for you and fits according to these basic rules and basic techniques. Okay. I want to answer any questions that anybody might have. I know we've done a couple as we went through, but it's important that I answer anything I can. Anything I missed, anything you didn't hear about that you're concerned about or interested in, I will answer anything. It's an open forum right now.
So Brittany's wondering, how often does a healthcare proxy need to be updated?
Oh, you know what? That's a good question. And again, something I didn't cover. But I'm glad you asked that, Brittany, because that's important. So, generally speaking, a good will plan is good for about 5 years. And one thing I didn't mention, too, is that for young folks, you have to pick a guardian, someone who will raise your children. And I will tell you, it is a difficult choice for most of my clients, but also this person, this particular job changes in your mind quite frequently. So I tell you that even though legally it's good past 5 years, 5 years is your rule of thumb. Whether you pull it out of the drawer, you review it, you say, are these people still the right people I want? Or you actually pull it out and make the changes. You should look at it every 5 years. The answer on changing it is how you feel about it. But I will tell you, as your children grow, what's going to happen is the people that you've put in various jobs and roles of responsibility, they're going to drop off and your kids are going to go in those jobs. So that's one of the factors you'll know that creates a change in everything. I will have clients come back and say, hey, get my brothers and sisters out of there, put all the kids in now. They're 22, 23, 25, 27. They can do all these jobs now. They can handle it. Okay? Good question. Thank you. Anything else you guys want to know? No question. Too silly, please. All right? So listen, we have on our website, we have all our emails there. We're available if you want to email Lizzie or myself with questions. We're happy to answer them. We'll do our best. If you guys want to come and see us, we're happy to see you and deal with your personal stuff that you don't want to ask questions about in this forum, and I understand that. Talking about your family and the dynamic, not something you want to raise in a public forum, but please feel free. We'll help you if we can. We have, good question, Brittany. We have about 6 locations. We do not have 2. So I go, Utica's our home base. We have Boonville. We have Lowville. We have Syracuse. We have Rome. We have Gouverneur. 6 locations that we go to. So because of the type of work we do is sort of, we can't really use the word specialized, but narrow, right? Concentrated. What we find is that we're able to travel to different locations, even other law firms allow us to come in and meet with their clients and do the kind of special work we do for their clients. So we have a lot of locations, and we'll travel wherever you are. So I'm in Syracuse once a month already. Happy to come to even your own office if that's something that would work for you. I'm happy to do seminars at your office for you or your clients or your staff or your coworkers, things like that. So we do that all the time. My location in Rome, we use, if you know Brian O'Shea, the O'Shea brothers, what's the address, Lizzie? Do you remember? Washington Street?
I do not know off the top of my head.
It's 2 doors down from the City Hall, right near that big parking lot. So we go there all the time. So if you're in Rome, that's great because we'd love to have people in Rome that we know. Okay. Any other questions? Any issues?
Any suggestions?
Any suggestions? That's right. Anything I can do better next time? Again, this is my first time, so I'm happy to take suggestions. I'm looking to build. Yeah, so if you're building a network, we'd love to present to your clients if you got 3 or 4 clients in a room, or I'm so used to saying in a room. Obviously, that's an issue right now, but We can do a private Zoom presentation just like this, private webinar for your clients only. We can do, and you could be here with me presenting as well, your piece, and then I do my piece or whatever. So I think there's a lot of opportunities that us sort of low-tech people have missed over the years because we've attempted to avoid it. And Lizzie has forced me kicking and screaming into the 21st century to kind of figure out how all this stuff works. So I appreciate her pushing me and you as well. Oh, I know it does, you know. Actually, there is a spot. Where is it on here?
Share screen.
Share screen. So whiteboard. So I can draw my boxes, right? Can you guys see that? I think it's neat, and I haven't tried it, but if it shows up better, I may entertain the idea of using that. Or if I'm in a location like even at my house where I don't have the whiteboard, I can use this whiteboard. Yeah, it's really handy. Even with my finger, I'm just using it. So this is my trust, right? So it still works pretty good. So how do I go back here? Stop share. There we go. Okay. So again, I'm learning. We're learning all these little tricks on this thing. But I appreciate that. Better than my drawing. We see you in a small box and the whiteboard is across. Right. So maybe it improves the situation. I ought to consider that. I did try it out a few times and was just concerned that I wasn't going to do a good job with my finger, so I went back to the old standby. So I appreciate that, though. All right. Anything else I can answer for you guys? Okay. The number, just to keep it easy, 624-9600. If you guys are inclined to call, please feel free, or please do mention that it was you guys attended this. We're probably going to treat you guys a little bit differently, price-wise, if you attended the webinar, just an incentive. Again, we're sorting this out, but that's my intent. Sort of a thank you for coming on and attending. So if we can help, please call, and we're happy to do it. You guys didn't ask, but there may be a question. I'm doing virtual meetings and I'm doing signings in person. Monday they're allowing us to do a little more work, opening up. But we've been doing signings. We were essential from the first week. So, but I would say 75% of our meetings are virtual right now. Yeah, very limited. We have a clean workspace that we use. We clean here. Obviously, everyone that comes in wears masks. So we're really being careful. We're going to follow the guidelines. So whatever the guidelines are at any given day as they change, we're sticking to those. So, so yes, and I was going to say something and I forgot. But we would do our initial meeting via Zoom, probably. I've been doing all my initial meetings just like we are now. I'd use my board and draw out your specific situation. So walk you through it, okay? What else? Lizzie, I was going to say something and I got sidetracked. I can't remember. I don't remember. But we would put you with me or Lizzie. Either one of us would talk to you guys at the initial meeting, and we'll walk you through it. Okay. I hope this was a good experience for you guys. I hope you learned something. I hope it was worth the whole hour you guys spent with me, so I appreciate it. Looking forward to meeting you guys in person at some point, if you're so inclined. And again, don't be afraid to email a question or comment or anything like that, okay? It's hard for me to look in the camera and not look at the screen, so I'm trying my best. If you're all set, I will sign off. I will let you guys go. Enjoy your evening. Enjoy your children. I'm going to go home and do the same. However, mine are 17 and 14. So to the extent that you can enjoy a 17 and 14-year-old, I will do my best to do that.